All right, I encourage you to, we'll be starting our keynote presentation here. Our next speaker is someone who knows a thing or two about making legal writing both precise and persuasive. Ryan McCarl is a nationally recognized expert on legal writing, and he's the author of Elegant Legal Writing. He's also a practicing appellate litigator in sunny LA, California. I told him the weather really lucked out for him today here in Minnesota. Today, he's going to share strategies to make our briefs not only compelling, but truly elegant. Please join me in welcoming Ryan.
Thank you all. It is truly an honor to be here, especially, I know last year's keynote was given by Ross Gruberman, I believe, one of my heroes. I've read and listened to his book, Point Made, a million times, taught it many times whenever I've taught legal writing. I am looking forward to speaking with you here today. I'm highly cognizant of the fact that there are appellate judges in the room, there are experienced appellate practitioners in the room, and that tends to be the best writers in the legal profession and the ones who also have the strongest opinions about writing. So I'm going to try to not say anything that's too remedial or covered in the book. I'll send you to the book, my blog, my LinkedIn for kind of practical tips and ways to implement what I'm going to talk about. But I want to talk a little bit about giving you some ideas of some kind of different mental frameworks to think about the obstacles that can come between your argument that you're trying to make and then the judges adopting it, in particular with the focus on readability. So I will just note only one thing about myself, which is that the fact that I am a practical litigation attorney, not just appellate, but also trial, and some of my focus on making briefs easier to read comes from a couple sources. One, that I'm trying to get the attention of trial judges who have sometimes 1,500 cases on their docket at once in Los Angeles. And so that's how I came up with the idea, for example, of the executive summary box above the table of contents at the start of a brief. Because you just want to make sure when I go to the argument, because sometimes I wonder whether it was read at all, the thing that I spent all those hours on. So now I make sure that if nothing else, there is at the top of the brief, right in front and center, a little executive summary, like a law review abstract. And I think it works. I would also say that I'm somebody who struggles I experience initial resistance when I try to read a text for professional work that I'm not picking up on my own volition. And I sort of sometimes struggle to maintain focus as I read them. So I think different people are good at that in different ways, and I think that motivation and attention is really variable to material, variable to mood, variable to energy level. But the fact that I kind of experience that regularly has combined with my love of language and literature and reading to help me think about ways, kind of generalize from that experience and imagine what it must be like to be a judge who doesn't really want to read about a particular case. As I was once a 10th Circuit clerk with that experience, and I know that sometimes, you're not reading for fun, you're reading for a duty. And so naturally, and it's competing with the brief that an advocate submits is competing with a lot of other priorities, family time, and so on. So you kind of have to earn the judge's attention. I want to talk about this. This is nothing too special about this. I came up with this idea on the plane ride over, actually. But I like it. We'll see if it sticks. The Readability Triangle. And kind of going along with what I just said, there are these 3 different considerations that are all related resources. It's hard to put them in any kind of order. Motivation has to do with overcoming that initial resistance and getting the judge to pick up your brief in the first place in time for them to process it before an argument, and then to keep them moving throughout the brief. Because if it's a brief where the advocates lost their credibility, or they've lost the judge's attention, or it's hard to follow, or it seems like it's not going to be very helpful, or it seems like the other side has a really dispositive argument that you're just avoiding, the judge's motivation can flag. If the text is very dense, there's long block quotes all the time, motivation can flag. And when motivation flags, attention flags too, because attention and motivation are really symbiotic resources. And they both tie into cognitive ease, which is just the fact that we all have limited mental resources. We're not like the AI programs who can, any time of day, process hundreds of pages of text and spit out a coherent response. We all have different energy levels, different sleep levels day to day, different things on our minds. And so a lot of what I've done in the book thematically and what I think about every day are ways to make life easier for the judge and ideally make it an easy glide path toward understanding my argument, because the judge has to read and grasp the argument as a prerequisite to accepting it. And it can't hurt if you make a good first impression with the brief and they feel a sort of sense of relief upon reading it. It can't hurt when it comes to their first impression about how to rule in the case. And the title of the talk the actual slideshow was writing briefs that judges want to read. Because I believe that it's possible in some briefs to write with such an art that momentarily at least the judge can forget that they're reading for duty and actually get engaged and sucked in and start reading it for pleasure. Sometimes with Supreme Court briefs written by the attorneys at the highest level of the profession, if you read their fact section, sometimes they can get a little bit gripping. And who in the room has read a novel by, let's say, John Grisham or George R.R. Martin or the Harry Potter books? I think probably quite a few of you. And if you think about these three elements, and for me, thinking back to when I was in college or high school, and I would just read a George R.R. Martin book, like 1,200 pages in 2 days or something. And how in the world is that possible? I can't even conceive of it anymore. Well, it's because the motivation was fun. It was fun. You want to see what happens next. Those authors never let your attention flag because it's moving so fast. They have such a sense of pace. And they're making it constantly interesting and vivid. And it's easy to read. It's not dense prose. It's a prose that makes images come to life. And we're not going to write a John Grisham novel in our appellate briefs, but you can think about that prose outside of the legal domains that you love and see what you can borrow from it in terms of style techniques. So I want to talk a little, I'll just mention a few kind of general concepts of readability and some of the implications they have about how to write. So with respect to working memory limits, there's something called Miller's Law. I'm sure many of you are familiar with. It's the idea of 7 plus or minus 2, the number of finite objects we can keep in mind at once. And an object, a linguistic object, can be an entire argument. It could be a particular claim. Could be a particular fact. As we progress through a text or through daily life, human brain's short-term memory can only accommodate somewhere between 5 and 7 objects at once. That has a lot of implications for how to write. It really means that you need to not overwhelm the reader with information in one space. You have to have a little bit of a flow through the document and introduce things a little bit gradually. And you have to make sure that information flow and complexity is managed, which can a little bit be in tension with the idea of being concise, because it is possible to write in a very information-dense way where you pack a lot of information into a really tight space. But you have to make sure that you are also creating enough time and context to parse it as you go. You also want to, I use an example in my book of a white-collar criminal appeal where the defendant who was convicted by the jury was convicted of like 17 counts. Well, it's really hard to get the judge to really think about 17 counts, right? So you have an uphill battle on appeal, I'm sure you can imagine. So what the excellent attorney who wrote that brief did was they just grouped them into 2 counts. I think it was 2 or 3. Like the securities fraud counts, well, that's these ones. And then there was the lying to auditors counts. Well, I'm sure the prosecutor would like to say, the government, defending the appeal would want to say, well, no, the jury independently found 17 different crimes here. got to treat them all separately, Your Honor. But on the other hand, if the judge adopts that framing, if it's a fair grouping, if it's a fair clustering that actually reflects, has some logical basis, then it is possible that you can win 8 counts at once and get them out of there. There's a lot to be said for that if you can make that happen. And that's because instead of 17 objects, you've made it 2 for the judge to think about. Hierarchy, just organization generally, it allows you to sort of think about one topic and then see how it relates to others and then mentally set it aside. I talk in the book about the idea of modularity and unity, the idea that you have each section and each paragraph be internally unified, meaning centered on the same topic, and it doesn't spill over into the rest of the brief. So there's not a lot of meta discourse about, as discussed in section 2 supra. It's just, you just keep moving and you kind of keep everything self-contained. You signal what that is by strong headings, which should be in sentence case, full sentence point headings and sentence case. And I teach that it should be the conclusion plus the best reason for that section. And then what goes into that section should be devoted solely to proving that conclusion. And next, gradual integration of information. So every judge comes to the table with a great deal of background knowledge. The advice I give about that is to assume that the judge and the clerk who might be helping write an opinion or a bench memo, they're competent lawyers, they have a lot of experience, more in some areas of the law than in others, but they may be a little rusty on the specific topic because we deal with so many different topics in practice and the law is constantly evolving. Most of us, after the bar exam is in the rearview mirror, start to forget what the elements of a particular claim are or exactly what the text of the statute is. So you can't just start writing on the assumption that the court's familiar with those. You want to make them available. But on the other hand, you don't want to say things that are self-evident. Like an example I provide in the book is when in an appellate brief, a lawyer explained what the concept of a standard of review is. Not what the standard of review is, like de novo or abuse of discretion, but like what it means as a concept, as though the judge, that's new to the Court of Appeals. So, and then this idea of progressive disclosure. This is borrowed from the domain of user experience, where I have found to be a very fruitful domain. A lot of different people in the world of tech are competing for attention, which is really what I'm encouraging you to think about you're doing in your briefs. And helping people process information and stay hooked on a product, one of the standard techniques used is called progressive disclosure. And what that means is you don't dump all the information at once in people at once. I remember back in the 1990s, all the GeoCities pages and the other web pages, it was one page and it had, like 1,000 words of text on it, and go figure it out. But that's not how it is anymore. Now we have menus, we have predictable website taxonomies. We know generally to look at the top for the menu. We look for the hamburger icon. There's certain patterns that we become habituated to as we become experienced users of the internet. And most importantly, we don't see information. It's hidden until we need it. So it's delivered, just like I think it was the Toyota assembly line. It's just-in-time manufacturing, just-in-time information. So the judge has the information that they need at the moment they need it and not too much before. This challenges this provides a reason to challenge and second guess and think about some traditional habits in legal writing. One is the aversion to footnotes. I go further than other people who discuss legal writing in recommending footnotes for a number of reasons. The primary one being that it gives you a chance to keep the flow of the main text going and it provides a visual separation between what's crucial for following the argument and what is reference or bibliographic or secondary in any way. And the judge can see it. And if they're interested in the point, if they want to know exactly what that statute says, if they want to know where to look up something in the record, all they got to do is look to the bottom of the page to your footnote citation, as opposed to plugging it all in as though it's all equal in the body text. That's the idea of progressive disclosure. Resolving uncertainty. So a great deal of what we do as we read is go through life is that we start hearing the beginning of a sentence or the beginning of an argument and start demanding resolution, just like when we read a story. And we want to know what's being talked about, where is it going? And helping the reader close those loops quickly and never have any doubt about what a pronoun is referring to, for example, or what your point is, or what the relevance of a detail is, can make the experience of reading easier and more pleasant, in part because it reduces the load on working memory. Eye movement, I mentioned the website example there, but also there's other ways to create visual emphasis too. I'll show you a couple of them later in the slideshow. But for example, you can use bulleted lists, numbered lists, tables, diagrams. You can do little inline bold for headings, which I'll show you an example of. But it should be pretty obvious at a glance to the judge what information is being conveyed on the page and what the most important information is. And then finally, none of us have infinite attention and motivation, and we have other things on our dockets. So what do we do with that information about those limited resources? Certainly, we should pay attention to them, rather than kind of assuming that the judge has a great appetite to read every page of our brief. So you want to be useful immediately and show that you're being useful immediately. You want the judge to conclude right away that this is going to not be too challenging of a read or take up too much of my time, and it's going to help me to read it because it's going to point the way, it's going to chart a path toward writing an opinion if I adopt this position. So when I was researching for the book and for the advanced legal writing class that I designed at UCLA a few years ago, I read a lot of books on general prose style, and in the past I've also done a lot of fiction and memoir workshops and poetry workshops, and so really kind of taken an ecumenical approach to ideas about writing. And a lot of them can be directly borrowed into legal writing. So again, just when you read prose going forward, when you read good prose especially, which you should always do, keep freshening your mind with non-legal language. Just kind of, when you read something that's successful, kind of read it on two tracks. What's going on with the prose style and what's going on in the content. Because the best prose is often kind of transparent, so you forget that it is prose. You just get into the mental world that's being created. But because you are all writing for a profession, you can see what you can learn and borrow from their techniques. Different ways to hold a reader's attention that are used in popular writing include that you're talking about characters performing actions. And that is a wonderful phrase by Joseph Williams. His book, Style from Clarity to Grace, is a classic of prose style. And the idea there is there's a lot of ideas packed into it that you hear in writing texts. One is that you want to focus on people with names rather than plaintiff and defendant, if you can help it. There are exceptions. There are reasons to do differently sometimes when you have multiple parties and things like that. But in general, if you can provide some kind of memorable names for people and concepts, if you can reduce unnecessary abstraction as much as possible, because the law is abstract inherently. It consists of general rules designed to govern innumerable fact situations. That inherently calls for abstraction. But because it's inevitable, you have to look for opportunities to get rid of abstractions and make them concrete whenever you can, whenever it's not essential to the discussion. And a lot of times, there are ways to write in concrete ways that can be visualized, that are, because one of the things that makes reading easy when you're reading a popular novel, for example, is that you're almost seeing it like a movie. You can visualize it, and you can see it as a narrative. And human beings just think in stories. We think in narratives. But abstractions are the death of stories and visualization, because certain things like, levels or res ipsa loquitur, can't always be that visualized too easily. Although I do think of the classic barrel falling from the second story, so maybe res ipsa loquitur is not the best example. And then pacing and forward momentum. The advice there, and I have a section, I think it's the third chapter of Elegant Legal Writing, I talk about sentence mechanics and how to accomplish some of this. But basically, there's a way to kind of propel the reader forward, and while having a cohesive relationship to the preceding text, and every sentence kind of moves seamlessly to the next. One of the things that I advocate is breaking free of sort of certain rigid formulas that can get in the way of pacing. One is excessive reliance on transition terms. Additionally, however, and so on. You can't avoid them entirely, and you shouldn't avoid them entirely, because sometimes you do need to expressly state the relationship between two ideas. You say however, and you've signaled a pivot. You say therefore, and you've signaled you're reaching a conclusion. Sometimes those cues are really important, but other times, some of us were taught in high school or before that you have to have a transition like that, an express transition between each sentence, and that's just not true. And if you read any good prose in the New Yorker or any good, really high quality fiction or nonfiction, you don't see that many of those explicit tags. But the writing is still cohesive, and no one's losing track of what's happening from sentence to sentence. It's just that can be done in a more subtle way. It can be done in a more subtle way. You can do things like, I talk about in the book an idea called echo links. Not my idea, but I find it helpful, which is just the notion of carrying forward references and themes throughout a paragraph. Basically introducing a sort of a character and then referring back to it, literally repeating a word sometimes, repeating a word from the same family of concepts. For example, if you're talking about a defendant being devious, or in I handle a lot of conversion cases, so we'll use words from the domain of theft pretty often. We'll talk about purloined and stole, made off with, heist. Those are echo links. They create a thematic thread and cohesion. They create a thematic thread through the writing that can perform some of those those functions without having the artificial use of a transition term. Fresh and direct language, cliches. Sometimes they are the first thing that comes to mind. And in a first draft, it's fine. You don't want to spend all your time thinking of fresh imagery in a first draft. But it is worth thinking about how cliches, usually originate as metaphors. Sometimes they can become confused over time. Sometimes they become completely divorced from the original idea. Like, I think just the one that popped in my head just now is the shoe was on the other foot or something like that. We now just think of the concept rather than literally a shoe being on the other foot. And cliches like that can have the effect of lulling the reader to sleep and having their brain go on autopilot. Whereas fresh imagery and fresh modes of expression can keep the reader interested, which is part of what we're trying to do. Sentence rhythm and variation. And Brian Garner in his book, Legal Writing in Plain English, if I remember correctly, says that sentences should be in the range of 20 to 30 words on average. I was shocked to find, after I finished the manuscript for Elegant Legal Writing, which I rewrote entirely after it was accepted. I rewrote the whole thing from scratch. I decided to check that out because I repeated that advice initially because I'd seen it in a number of places. Seemed to be the standard advice. But then I ran a test on my own manuscript, and I found that the average number of words per sentence was 11. So actually, it's possible to write much more trimmed sentences. And I think that is one reason that the book is easy to read and fast-paced. Before I went to law school, I taught 9th graders and 10th graders, and it was always trying to think about how to get them to read about history. And I don't know how successful I was in reality. I didn't babysit them. But I did everything I could to make that achievable by giving literally 2-page reading assignments so that they could read it in the morning before class, like I might have done in high school. And the shorter sentences create pace. Shorter sentences and paragraphs automatically create a faster pace. And they make information easier to digest by breaking it into more bite-sized chunks. That doesn't mean that they should all be short. In fact, there should be quite a bit of variance in both structure and length. And the same goes for paragraphs. But in general, keeping it short is always a good idea. I've never heard of a judge complaining that a brief is too short. I've heard of judges complaining of the opposite. But nobody's ever going to complain that your legal document is too short. So I thought about overcoming this initial resistance. And again, this may be more of a trial judge issue. I don't know, when they have 1,500 cases, and I can't even imagine what that must even entail. I have to just imagine things go unread. Because I can't personally fathom keeping track of filings in 1,500 cases at once. And I know that appellate judges, they don't know they have 1,500 to my knowledge at once. But given that there's going to be an initial competition for the judge's attention and how they're going to devote their time, how can you encourage them to devote their time to your brief right from the beginning? I have on the right-hand side here a motion to strike an answer that I wrote when I was a pro se plaintiff suing my landlord early in my legal career. I was the pro se plaintiff from hell, I'm sure you can imagine. There were at different times 12 lawyers on the other side. And I wrote this one-page motion, and I think that is the ultimate power move in legal writing, is to write a 1- or 2-page brief. I've only pulled it off this one time. More recently, I was able to do 2 pages, but this was granted. It's not that it was an issue that was. The thing about it was that it was actually a really unusual situation that I haven't seen before or since, which is that the defendant, it was the subsidiary of the parent company. I sued the parent company, who had the brand, and they insisted that I should have sued the subsidiary. So they literally had the subsidiary come in and file the answer. Well, the parent did not. The actual defendant did not. So unusual situation, but I thought, this is not position that any reasonable attorney could have, that a different party can just show up and litigate in place of the actual defendant. And so I kind of distilled that to its essence and was able to file it on 1 page, and it was granted. Short document is a good way to get read. Short sections within the document with an informative table of contents. If you follow my suggestion of writing headings in the format of conclusion, because, best reason, with stylistic variations on that, but essentially that content, then your table of contents should function as an argument summary and show the judge in advance where you're going to go and what your best reasons are. And it can get them, hopefully, cue them to be thinking ahead about the plausibility of what you're going to say. So they're less likely to go in with so much resistance. Short sections, short paragraphs, those are all things that make your brief more inviting. Document design, I devoted a chapter in my book to document design. A lot of the ideas that I share there are from one of my favorite book on the topic is Matthew Butterick's book called Typography for Lawyers. It's a beautiful book. You should buy it, but it's also online. You can see a lot of it online as well. So I read that, and then I read some other books on design and typography having nothing to do with the law. Mostly, found that there's a lot of overlapping advice that doesn't square with how we actually format legal documents. For example, clean, uncluttered margins. A lot of law firms will put their branding in the margins so that you have the full law firm address in the bottom margin of every page, just in case the judge wants to mail the firm a letter in the middle of reading the brief. I don't know. Or a fax. There's a fax number there. We need the fax number in the footer too. Even this brief on the right, I've gotten rid of in my current templates at my law firm, Ryan McCarl LLP. I've gotten rid of the line, the bottom. Well, why do I need that line? Negative space is visual designers and typographers are talking constantly about negative space and minimalism and decluttering. And the same goes for the margins of your briefs. Same goes for, avoiding big blocks of text. I've recently tried unsuccessfully to read Kant, just to like help myself sleep at night, like critique of pure reason. And I mean, that's not a humble brag because I can't do it. it's actually really hard to follow and really boring. And you'll have literally 2 pages of dense text with no paragraph breaks, because back in the 16th, 17th, 18th century, you read Adam Smith, you read the founders, the Enlightenment thinkers, they didn't have the same paragraphing practices, so they just didn't break it up very much. And boy, is it hard if you are tired or sleepy or not super motivated to slog through a 4-page paragraph. The footnotes are one. This is my second argument for footnotes, would be that they do give you a chance to increase visual variety. They avoid, multi-line citations in the body text, things like that, which just kind of contribute to blocks of text. And finally, once they do open your brief, because it was so short that, I'll get to this one first, I'll do everything else later. Then you have to show that it's going to be helpful by showing your request for relief, what exactly remedy you're seeking, and then what your best reasons are right from the beginning. Yeah, I think I say in the book that legal document's not a mystery novel. You have to tell conclusion first, I think, is the uniform writing advice. And I add to that conclusion plus best reason, and getting to the point of what that is very quickly. And I've spent some time recently critiquing the CREAC framework, but it's still the dominant framework taught in law schools. It used to be IRAC, which IRAC is worse because that does treat it like a mystery novel. Here's the issue, and then eventually I'll explain what the answer is and why. But we'll start with a kind of a rhetorical question. That's not really taught, I don't think, as often anymore, but what is taught is this idea of this acronym called CREAC, C-R-E-A-C, conclusion, rule explanation, application of the rule to the facts, or analysis, depending on who you ask, followed by repeating the conclusion. Well, I've just never seen any good prose written that way, I'll be honest with you. Why in the world would you need to repeat the conclusion here and here as though you've forgotten it? If they've forgotten it in the meantime, that's you got bigger problems. You must have some boring text between those 2 items. But the real problem that I think has proliferated in the profession and in a lot of briefs that I think CREAC promotes is excessive reliance on rule statements and verbose rule statements. Not every rule needs an explanation. We don't need to know the policy reasons behind a federal 12b6 motion, or federal rule of civil procedure, or an evidentiary provision that everybody knows, like the hearsay rule. Doesn't require explanation. The only rules that you need to explain are ones that are confusing. And if you just put yourself in the mindset of thinking about what does the judge actually need, they don't need an explanation of the policy rationale for a rule most of the time, because it isn't going to be the basis of their decision, because it can't be unless it's correct on the law. Policy arguments can't trump legal arguments. So I also see like a legal standards section is low-hanging fruit. It's the easiest thing to write. A lot of times you can just plug in something from a past filing. Here's our firm's standard motion for summary judgment, rule description. I've seen firms spend 4 pages talking about a 12b6 standard. And that to me, from the perspective of a judge, looks like you don't have the goods, because you must be afraid. You must not have an argument, because you seem to be really procrastinating on getting to it. So figure out ways to get to the point very quickly, both within sentences. Usually that means shifting subject and verb to the left, so that you propel the reader right into the heart of the sentence and what matters, without saying that you should also have structural variation. But in general, you want to get to the point very quickly. Avoid long wind-ups in your sentences. Avoid too much meta-discourse, like traditional roadmaps. First, I'm going to say this. Then I'm going to say this. Finally, I'll say this. Try to just see if you can do without that, and convey in more subtle ways where you're going, so that you can get to your best reason right away. Preview that, and that's why the fastest way to do it is right in the point heading. And then you want to, again, think about why the judge is reading the brief and not get carried away with your own mentality as a writer, which is very easy to do. And think about your needs and your wishes, such as, boy, I did a lot of research, found some great cases. I found 5 great cases on this point. I'm going to put them all in there. Well, the judge may not need 5 cases to make that decision on that issue. In fact, they might be more likely to go with you on that issue if you do 1. Because if you do 5, you make it seem controversial. But maybe it's not controversial at all. If you do 1, and it's the highest court in the jurisdiction, and it seems squarely on point, you move on. So think about at all times what the judge is trying to achieve and how you can be helpful to them. And I try to think about my own role a little bit as a teacher of the judge. I'm teaching the judge the rules and the analytical moves, reminding them of the rules and the analytical moves that you need to reach the right decision, which is one for my client. And that, of course, and really, I always, one thing that we do in our firm is we just don't make arguments that we don't believe in. And so that means leaving arguments on the table that theoretically you might be able to get by a judge or something, but I just don't believe in trying to win by misleading the judge. And I think that if a judge sees you doing that, you're going to sacrifice, the rhetorical idea of ethos, the advocate's credibility. Whereas instead, if you just speak as though you're a mouthpiece for the law, and the law is kind of speaking through you, then you do get that, you do build that ethos and that trust. And the judge can start envisioning what it might look like to actually write an opinion ruling for you. Thinking about how to allocate that space and that time that you have in your brief with the judge. There's this idea the world of algorithms in computer science called the knapsack problem. Knapsack, I think, means backpack. And it has to do with if you have a backpack and high-value items that you're going to put into it, but they're all different shapes and sizes, and you can't fit them all in, what's the highest kind of return on investment you can get? What items should you select to get the highest value for that total package within the constraints you have? And a couple of different factors to consider when you think about how to allocate the space and among different issues and which ones to omit entirely would be think about what's important. If you can't envision an argument being used as the basis for the ruling, then probably shouldn't include it, because why would you? If you don't think that a fact is material enough to be mentioned in the opinion or sway a decision one way or the other, probably shouldn't mention it. So importance is, I think of importance in terms of potential to actually be decisive or be part of a sufficient set of decisive reasons, even if it's not individually decisive. Contestability, again, if it's straightforward, like the 12b6 standard, that should get very little space in your brief. And whenever you say, write a rule statement that just can't really be argued with, like maybe you have a quote from a Supreme Court case, that's that. Hasn't been overruled, that's the law. They can't argue against it. So therefore, you just say the proposition, cite the rule in a footnote, don't even need a parenthetical, don't need to say what other case was being quoted when they made this statement. You just move on, because why would you devote space to something that can't seriously be contested? And then finally, issue complexity. And this goes back to being helpful to the judge. Even an issue that must be included, but is kind of harder to follow, naturally justifies taking up a little bit more space. Okay, thinking about managing complexity. I think about what I do as a lawyer as charting a path through the inherent complexity of the law and trying to help the judge kind of scaffold the information, find out what the right framework is for a decision, and then work step by step through it to the conclusion. It's so tempting because there are so many different evidentiary facts in a complex case. There are so many different legal points and so many different facts of great cases you found. it's just so important to try to keep to the essentials. And concision promotes every other aspect of readability because you have less complexity to convey if you just avoid including details in the first place. You spare the need to even make entire arguments because, upon reflection, they're not going to win. And there's just ways to, clearing out the clutter makes your brief more organized, makes it more likely to be read, more likely to be understood, and above all, most likely for the judge to focus on the right things. There's this Paul Grice, the linguist, has something called, I don't know how to pronounce the name, but Gricean framework, maxims that I learned about in a linguistics class in law school. And one of them is called the maxim of relevance. And what that means, as I interpret it, is that whenever you share a detail with somebody, they're always trying to kind of concoct a theory or a narrative in their head, and they're trying to slot that detail in somewhere, see where it's relevant. And the maximum of relevance is that, a part of what it means to be a good conversational partner is that you only share relevant details in the first place, so therefore you're not leading them astray as they try to figure out where to put this detail that actually is superfluous. If you put a detail in there, you risk it being focused on, and it may be that you want the judge to focus on something different. Over quotation, I think, is a significant vice. This is something I learned from, I think Brian Garner talks about it quite a bit actually, which is that for a lot of purposes, paraphrasing is better for all sorts of reasons. Because first of all, there's a lot of verbosity in judicial opinions a lot of times, and especially because there's sort of time-worn formulas, that have been handed down over the decades in opinions, and quoting them may not be necessary. You want to be precise when precision matters. Like, for example, the text of a statute, if there's an interpretation issue, or the text of a contract, or the text of even a quote from a case where that quote is particularly effective, or where if you just paraphrase it, it's going to seem counterintuitive and you want to show the judge the source. But in general, writing your own words rather than importing quotes is much better. For one thing, it promotes cohesion because you are integrating words and concepts into the sentence based on the immediately preceding text and context that you've written, as opposed to essentially pivoting away from it sometimes by using completely different language that spans 2 or 3 lines. If you think about storytelling, I mentioned this earlier, but as everybody knows, one of the things that makes a good story is characters. And sometimes that's hard in the law when you have complex litigation involving companies, for example, and you're dealing with abstract concepts from securities law or regulations or whatever. But just always try to think about how to personify them, how to make them familiar. And nothing's too remarkable about this example, but it's just that these 3 companies in this partnership dispute we litigated, the court has to know them. They're extremely important. They're pivotal. And, JCM Ag Management LLC, JCM Realty Holdings LLC, that was later renamed as something else. Boy, that's getting hard to keep track of. So what did we do? Just a simple solution. We, at the very beginning of the case, right in the complaint, we decided these are the names for these companies. They're the short names, easy to write, and those are the names that we're going to use the whole litigation all the way through. And we're going to teach them to the judge by putting them out in bullet points and bolding the names. This is an example of that progressive disclosure idea with footnotes. So you can see here, this is actually from opposition to a motion for summary adjudication, which is like summary. I don't know if they have it here in Minnesota, but in California it's like summary judgment, but it can be to particular claims, not to the whole litigation. And the defendant who moved for summary judgment went into court on an ex parte motion to request a page limit increase and to increase to 25 pages. Guess how many issues they moved for summary judgment on 25 different claims. So 25 pages to cover that. And I showed up at the ex parte hearing and said, we don't oppose it, but I'd like to get more because I don't know how I'm going to deal with 25 different motions for summary judgment effectively in 25 pages. So I actually think this was a strategic gambit on his part, not a bad one, to basically constrain me from writing, mounting full defenses. But what it meant is we had to convey the key facts in a very compressed way to stay within that limit. And this is an example of how to do it. So we just have the main text, the body text is for the narrative and the main thread. This is from the fact section, obviously. Rose siphoned the business's money to his affiliates at every turn. He dipped his hand into the till to reimburse himself for personal expenses, repay non-existent loans, and compensate shell companies for services never rendered. Well, that's what happened. Those are pretty inflammatory as well, right? And it would take some of the bite of it out if I had citations breaking it up the whole time, like most firms do. But I can understand the court may want to make sure that this is actually what happened here, because it was really dipping his hand into the till metaphorically. And in that case, if the court's ready to learn that information right now, what backs that up, you just follow right down to the bottom of the page. And what you have here is not just, you could just say Dennis Declaration Exhibits 16 and 18 and then leave it there. But again, we're trying to be helpful. We're trying to make the judge's life easy. So therefore, we use parentheticals describing the exhibit. Expense report for dog food. Well, that does seem illegitimate. Safe log excerpts for personal. That does seem like dipping your hand into the till. So the judge sees it, says that, okay, appears that they have the goods there, keep and move on. Adjusting to the reader's background knowledge and their needs. Nothing too special about this. This is part of a table of contents for a brief, one of our motions to dismiss. And I don't see firms do this very often, so I wanted to just share this little trick, which is that the legal standards section, as it's normally called, I called relevant law. And most legal rules I'm going to discuss in the context of the actual arguments. I don't believe in delaying the arguments by 10 pages while I explain all the rules in advance. But the overall procedural framework, the overall framework for deciding the motion, or the sort of most outer level rules that the judge will apply, those probably do belong in a legal standards section because they're going to apply throughout many sections in the brief. So do it once in front. I think of it as like, I always think of the metaphor of like factoring in math, where you pull out, you pull out, I'm so bad at math, I shouldn't use this example, I don't even know what it means, but you pull out the common thing in the equation. There's one common term in 3 different areas, and you pull it all out and you put it in front. I do that. That's what legal standards section is ideally for, and that's also what umbrella text is for. I spent a lot of time thinking about, if you've probably heard of umbrella text or umbrella heading, or what do they call it? Umbrella paragraphs, bridging the gap between top-level heading and then a subheading. Well, what do you do with that space? Since that is thought of as the best practice, well, that's what I do with it, is that if there's something common to all the different subsections within that outline level, I filter them out and I move them up front. And then what do I put in that legal standards section so the judge doesn't just skip it if I don't want them to skip it? I tell them exactly what they're going to find in that heading. They're going to see a motion to dismiss standard. That's probably skippable, but look, it's only 1 page. And then they're going to find out, okay, so conversion and secure transactions, that's not something that most people deal with every day, is those two in the same exact issue. So the court can quickly go there as a reference point and figure out what's the basic framework for thinking about that. And when you think, I mentioned this already, I won't belabor it, but just when you with every detail during the revision process, question whether it really pulls its weight and it justifies the complexity that you're adding. When you decide on which details to include, they should be, for factual details, both important and salient, which we talked about what important means. Salient can mean something you can visualize, something that is likely to stick in the reader's mind as an image, something that may have some emotional force. And a couple different, I have on the slide here, just a couple different considerations to think about, and I'm running a little on time, so I'll move faster. But the same thing applies to citations as goes for factual details. So think about exactly what role each citation is playing in your argument. And I'm writing a new manuscript right now about argumentation, motivated in part by my dislike of CREAC and IRAC and thinking that that actually kind of misses the point of almost all legal analysis in hard cases. So, because normally you don't just have a ready-made selected rule that everybody agrees on with ready-made accepted facts. That's usually we're arguing about what the rule is and whether it even applies to the facts. So I'm writing about that now, and so I'm thinking a lot about argument maps and how different, what the purpose of citing something is. And one is just to say, well, here's the standard for a motion to dismiss, and here's my citation to back up that rule. But the interesting citations are those, the ones that you have to spend a little more time on, are ones where you're doing analogical reasoning, which is focused on a lot in your 1L classes, and sometimes described as being the essence of legal argumentation. I wouldn't necessarily go quite that far, but I would say that you would need to do that when there's when you're trying to infer a rule from cases, or when you're trying to kind of bridge a gap between a general rule and the facts at hand. So, in this argument map, this is a case we litigated on the defense side of securities fraud. And the person who was accused of actually committing the securities fraud, which was our client, had invested in the exact same products as the plaintiffs. So, and he'd also given them out to his family, not given them out, but had his family invest too. So he'd lost hundreds of thousands of dollars, so did his family. And so I thought to myself, surely that should negate the scienter element, the mental state element. If it seems to me that you seem to believe the truth in what you're saying if you go and buy your own stock. And so I found a case saying so. And what's the role of it? It is I infer from the case, this Ninth Circuit case, the existence of a rule that is not to be found in the treatises, unless I put it there since, which is that if an investment promoter has the same incentives as the investors he solicits, probably does not intend to defraud the investors. That's my new legal premise. I think it's adequately defended by the case with an informative parenthetical, so the judge doesn't have to go read it. And that is paired with a fact premise to reach a conclusion. Every citation's got to be there for a reason, and usually you only need one. Okay, a quick tour of visual aids here. Things that we do in our briefs. This is the fun of starting my own law firm with my partner, John Rushing, back in 2020. I had nobody to tell me, I can't do that. You can't do that. That's not how we write. We don't do that. Like I had at the big firms beforehand, where you had 4 layers of hierarchy, and someone in that hierarchy is more conservative about writing practices and is not going to be using footnotes or whatever, and certainly not going to do something like this or put a QR code in briefs. But I don't have anyone to tell me no, so I'll do whatever I want and try things out. So this is my executive summary box that I invented and have been using ever since, part of our firm's standard template now. This is just an example of a case that we have where the facts are actually quite simple, but what is confusing is that there are a bunch of different key players, some of which, quite unfortunately, have almost the same name, DSS something, and are on different sides of the caption. So now, how in the world are we going to get the judge to figure out which is which? So we, used some Microsoft Visio, came up with this, this to show the relationship between the parties. My law firm was the first in the country to sue Pacific Market International, which is the maker of Stanley tumblers. So we're litigating a class action against them with like 12 other plaintiffs' firms or something like that up in Seattle. And in our complaint, one thing we did was we talked about their Stanleys. Oh, I should mention they have lead in the tumblers. That's the reason that they were selling these partners, advertising or these tumblers, these cups to parents, advertising them for kids, and didn't mention that they had lead in them, and that if the cup got damaged, you'd be exposing your household to lead. So we showed how they're advertising it to breastfeeding mothers. This is why I knew about this issue, because I had a daughter, 6 months before, and my wife had gone out, like so many others do, and buy Stanley cups to carry around milk. And so that's one thing I did. We have there is just a screenshot of evidence. And then on the right is the fun part. I'm pretty sure we're the only firm in the country that has done this, and we invented this too. which is you can just go visit that actual ad by scanning the QR code for as long as it's still online. We've also done that when, in the case where we moved for sanctions and moved to compel on a deposition, and noted to the court that the defense counsel was coaching the witness. And the defense counsel, of course, vehemently denied it. So in the reply brief, well, if the judge wants to see it for itself, just scan this and you'll see the video where the defense counsel leans over while the question's pending and whispers in the ear of the witness. Tables, very simple tool that is sometimes has a lot of good uses for certain information structures. And many other examples that I post on LinkedIn all the time, on my blog all the time, elegantlegalwriting.com, less frequently there, but I'm always just trying to come up with different ways to make life easier for judges and to get them to start reading my briefs and then keep reading them and stay engaged until the end. So thank you all for your time. I think we probably ran out of time for questions, but I'll let you decide that, and then I'll stick around for a few minutes if any of you wants to chat. Everybody is welcome to reach out to me as well.
Well, please join me in thanking Ryan.